To have everybody. Sorry, I'm a couple minutes late. Had some guests from Christian County from the home district in my office, and they're more important than all y'all. I mean that, Senator. Constituents always come first. Am I wrong, anybody? That's exactly right. All right. Madam Secretary, Mr. Secretary, please call the roll.
Senator Berg. Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder. President Stivers. Senator Turner. Senator West. Senator Wheeler. Senator Carroll. Chairman Westerfield.
Sorry about that. My mic was off. I'm here. We've got a quorum. We're going to go ahead and jump right in. We're going to go in reverse order here to accommodate availability of our speakers. Senator Julie Rocky Adams, Majority Caucus Chairwoman, please come on up on Senate Bill 38, an act relating to incest. And you've got some guests with you. I'll let you take the floor, Senator, and you or your guests can introduce yourselves, and you can proceed.
Thank you very much. Thank you, committee. I am Julie Rocky Adams, State Senator, District 36, and I will let my guests introduce themselves. Make sure you push the button.
My name's Kathleen Neistat, and I am a survivor of childhood incest, and I am here for support.
Hi, my name's Lakin Albrink, and I'm also here as a survivor of childhood incest.
And they were the ones who brought me this bill idea. And actually, the bill itself is just mainly a housekeeping measure. And before I let them tell their quick story, if you notice in Section 1, it's the violent offender statute. And all of this does is just include on page 2 incest as described. So all that means is it is we are going to put that under the violent offender statute, which means that anybody who has been convicted of this crime has to serve 85% of their time. You want to tell your story?
Yeah. Thank you so much. I really appreciate the time that you're giving us to talk to you about this important issue. As a survivor of incest, childhood incest, I was sexually abused by my stepfather for many years. He was later convicted after a trial and sentenced to 25 years. However, very soon thereafter, he was parole eligible at 15% serve time, which is what is currently the serve time to be parole eligible for incest as it's written now. And so it's really important to us that we work to get incest classified as a violent offense, as is the other sexual offenses that are listed. I think it's excluded because it's not in Chapter 510 where the other sexual offenses are listed. It's actually in the family offenses chapter. And so including that, I think, is very important because sexual abuse to a child is super traumatic, and it is only compounded each time you go to the parole board. And putting that off to 85% would just be tremendous for survivors. So thank you so much for your time.
Thank you.
Any questions? Yes,
Senator
sir.
Schickel.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this before us. I do have some questions, and I probably need some assistance maybe from some of the lawyers on the committee. Because I read this and it refers to another statute, and for a layperson it can get kind of confusing. What about a situation where you have minors, let's say very much minors, let's just, for example, 10, 11 years old, and together and have, would this apply to them?
It would only apply to Class A and B. The way I read it, Class A and B felonies, as in the higher part of the section of the statute. And so if the crime is not an A or B felony, which I don't believe that would be the case in that scenario, then it would not.
Yeah, it doesn't differentiate age of the suspect. It doesn't say anything about the suspect's age. It's just the victim.
You can,
So-
Senator Schroeder. I mean, go ahead.
Thank you, Mr. Chair. KRS 530.020, Section 2, subsection A has incest is a Class C felony if the act is committed by consenting adults. B goes down to say incest is a Class B felony if committed, and then it has one, forcible compulsion. It has refers to another statute. Or two, if the victim is less than 18 years of age or incapable of consent because he or she is physically helpless or mentally incapacitated. And then C of two, incest is a Class A felony if committed on a victim who is less than 12 years of age or the victim receives serious physical injury.
Mr. Chairman,
Thank you, Senator. Yes, sir.
would it be in order for me to ask another member of this panel a question? I would just like to ask Senator Schroeder, the way I phrase that question, because I'm still confused, what would be the answer to it?
All right, let me clarify. Are you asking whether or not a child could be charged, or if a child victim?
I'm asking is if two juveniles, 10-year-olds, have some sort of consensual relationship, and both of them are not, neither one of them is mentally incapacitated, does this enhanced penalty apply to them?
Yeah, I mean,
And they're related. Let's say two brothers.
that's what I would say, Mr. President. The definition of incest is pretty clear. It requires there to be that familial relationship. But even then, that familial relationship is enough under 2A, even if it's between two adults. But the bit about being an adult isn't required under 2B or 2C. Then it's based on how you commit the act and the age of the victim upon which the act is committed.
So the answer to my question, Mr. Chairman, is yes or no in your opinion?
I think it's possible, yes.
Okay, thank you.
Yeah, because the statute does not differentiate age of perpetrator.
That's right.
Then it would necessarily fall
Good.
within the adult range if they are charged with that crime.
Thank you. Thank you, Chairman.
Does that answer your question? Senator Schroeder?
Thank you, Mr. Chair. I was just going to point out in the beginning it does talk about it has to be sexual intercourse or deviant sexual intercourse.
Any other questions? Yes, Senator Carroll.
Yeah, and to continue this conversation on, and it's been a while since I've dealt with this. So, how would the violent offender statute, how would that apply under juvenile proceedings in relation to the 85% served? I mean, how would that factor in?
It wouldn't unless you've been transferred as a youthful
as an
offender.
adult, yeah.
If your juvenile case has been waived up to circuit court as a YO, then you are any adult sentence is available to you, including the parole eligibility set forth in 439-34 or 439-3401, which is the 85% statute.
Okay.
Senator Stivers.
This is just kind of along the lines of what the definition of intercourse, or this is not one of the more, socially acceptable discussions that you would have around drinks in the evening, but I think intercourse is defined as penetration of certain parts of the slightest. So there does not have to be any damage or anything else to hymenal rings, anything of that nature. Deviant sexual intercourse, I think, has a totally different definition, and you have to go back to the definitional sections to see when, Senator...
Both are in the definition.
They are. So to Senator Schickel's question, I think it would be almost fact specific as to what the acts were and if they were covered by the definitional sections of sexual intercourse or deviant sexual intercourse before you start getting into how it would apply under 439-3401, if I'm not badly mistaken.
Senator Wheeler.
You know, and I guess maybe, and I think you alluded to this, Mr. Chairman, you know, I would assume there would have to be a fact finding also that the behavior, even amongst the two juveniles described by Senator Schickel, would have to be of such abhorrence or you know, significantly violent / deviant behavior to get it out of the juvenile system up into adult court, would it not?
The factors are set forth in statute that a court has to consider, and the Commonwealth through the county
and
attorney
I'm assuming,
would consider.
and I don't want to speak for you, Senator Schickel, that what you're talking about is maybe people that just, for lack of education or lack of, you know, ignorance, that they do something that might run afoul of this statute and then find themselves as a violent offender. So I think under that scenario, the court would look at the totality of the circumstances and have to transfer it to adult court for this to apply in that manner. I think if it was something that was, you know, inadvertent, out of ignorance, that would probably remain a juvenile action and not be covered by this. Would that be correct, Senator Adams?
We're not changing any definitions of incest. We're just working off of the fact that these people have been convicted of a crime, and we're just inserting incest into that so that they have to serve 85%. But we're not changing any definitions. We're not changing any crimes.
That's right.
We're just talking about the time served for people who have been convicted.
Thank you for that. That's correct. Doesn't change the definition of incest at all. Any other questions? I make a motion on the bill. Is there a second?
Second.
Second from Senator Schroeder. Any further questions? Seeing none, Mr. Secretary, please call the roll.
Senator Berg.
Aye.
Senator Carroll.
Aye.
Senator Kerr. Senator Neal. Senator Schickel.
No.
Senator Schroeder. President Stivers. Senator Turner. Senator West.
Aye.
Senator Wheeler.
Aye.
Chairman Westerfield.
Aye. The vote count is 9-1 for those watching at home. Bill passes with favorable expression. Thank you, Senator. Ladies, thank you both for being here and for sharing your story.
Thank you so much.
While we're asking our other colleague, Senator Higdon, to come on up on Senate Bill 33, Senator West has a guest to introduce.
Thank you, Mr. Chairman. I have with me today members of the Kentucky Land Title Association, and I'm a proud member of that group as well, and we're the ones that make sure your homes have no judgment liens. So welcome to committee. Thank you.
Glad to have you all. Thank you, Senator. All right, Senator Higdon, Senate Bill 33, an act relating to expungement. Sir, you have the floor.
Thank you, Mr. Chairman and members of the committee. I've been here before talking about expungement, and I think we've done some good work in that area. This, my previous expungement bill dealt with felonies. This deals with misdemeanor expungement. There's about 180 bills, 180 misdemeanors right now, I think, if I'm right, that fall under this category that have no expiration. They can't expunge them. Under current law, KRS 431.078, a person convicted of a misdemeanor or a series of misdemeanors arising from a single incident may petition the court in which the person was convicted for expungement of his or her misdemeanor record, as long as the offense was not a sex offense or offense committed against a child. The current law, however, does not have a provision for expungement in the event that offenses may be enhanced with additional penalties on an indefinite basis. Senate Bill 33 amends the statute to permit a person convicted of an offense that is subject to enhancement on an indefinite basis to petition the court for expungement, provided a period of at least 5 years has elapsed since the date of the offense. And primary reason for doing this is, enhance employment opportunities and add clarification for the Kentucky State Police as they work through these expungement. Like I said, there's 180 different misdemeanors that currently fall in this category that have no expiration date, and some of them as simple as violation of a stop order for buying, selling, or processing eggs without a license. Transaction of a business by an unlicensed person with a permit to permitted producer of milk. Buying and selling mussel shells or mussels in the shell without a license.
I tell you, we're really friendly to criminals on this committee.
I know. Well, spitting in a food establishment. But there are some that are obviously more egregious than one, the failure to comply with temperature requirements for a refrigerated locker. And receiving alcoholic beverages from a carrier in a dry territory.
Prior to that one, those others are misdemeanors in our code?
Yes.
Wow.
They're all misdemeanors, enhanceable misdemeanors. And there are some,
In case you spit twice?
You can
Is it really?
Can be enhanced. There's some that are a little more egregious, using the title of doctor without a degree, criminal gang recruitment, assault of a sports official. There's some stuff in here and some narcotics
Sure.
possessions and that sort of thing. So, but a lot of them have a 5-year look back. DUIs you're very familiar with has the 10-year look back. But a lot of these have no look back. And what this bill would do would simply say, if it doesn't have a look back, if it doesn't have a time on there, that'd be 5 years. And after 5 years, that misdemeanor, you could apply to have it expunged.
Any questions for Senator Higdon? Senator Wheeler makes a motion, a second from Senator Turner.
I've got a quick question.
Senator West with a question.
Thank you, Mr. Chairman. I know on some of these bills in the past, we've gotten into the idea of looked at fees. What would happen with if someone wanted it expunged? Is there a fee involved with that?
There is, and it's been in the statute for quite some time. It's a $50 fee to apply for misdemeanor expungement.
And I know your bill has nothing to do with that, but I was just curious.
No, it doesn't change. There is a $50 application.
It's actually
fee.
$100 there. The first $50 of each fee collected pursuant to the sub.
Okay.
This is on page 3.
Right. The $50 stood out, but you're right. It's $100.
Okay. Thank you.
And
I just want to say, and this is not at all directed to you, Senator Higdon, but to the trial court judges in the Commonwealth, I am frustrated by our Supreme Court's ruling that removed the fee on expungement at petitions. They did that, and they wanted to do that in a service to the poor of Kentucky that want to apply, and I appreciate that. But we wouldn't have had the fee in there in the first place if trial court judges, all of whom I have immense respect for, and other practitioners on this committee have a ton of respect for as well, if they actually made an inquiry into the needs of the defendants in their courts. I don't see that being done ever. I just don't see, and I don't know any other practitioner that sees that being done on any sort of regular basis. There's a lot, and DPA would tell you, I think, that there's a lot of the people they represent that shouldn't be represented by the Department of Public Advocacy, which thins the resources for the ones that do need representation by the Department of Public Advocacy, not to mention everything else. We need our trial court judges to actually make an inquiry and hold people accountable. And if they are not entitled to a DPA counsel, they need to get their own lawyer and free up those resources for the ones that actually do need DPA counsel. And if they were making that inquiry, we wouldn't need the fee to collect. This is a fee. The fee that we put in statute is pretty modest, and I don't. So if any of you are thinking about bringing a bill that codifies what the Supreme Court did, if it comes to my committee, good luck moving it forward. I just wanted to say that because it came up, Senator. I'm going to vote for your bill because I support it.
Thank you, Mr. Chairman.
And I gave it a hearing. Senator Carroll.
Thank you, Mr. Chairman. Senator Higdon, what are some of the drug offenses that do not have specified years for enhancement?
Let me get past the violation on the milk. And this is just, I'm just going from the top to the bottom here. Willful non-compliance of labeling of a prescription, advertising a controlled substance, trafficking in controlled substances in the third degree. It's a Class A misdemeanor, enhanceable. Trafficking in marijuana less than 8 ounces. Cultivation of marijuana less than 5 plants. Trafficking in a synthetic drug. Trafficking in or transferring a dietary supplement. Possession of 1 gram or more of pure, what that big word is. Skip that one. That's, if you want to look it up, it's 218A.
That says dextromethorphan.
Okay, thank you, Mr. Chairman. There's a lot of distribution by practitioner or pharmacist.
Let me ask, what was the question?
What are some of the crimes
related
dealing
to
with with drugs?
Sorry, thank you.
There's several of them there. As you would, most any felony, there's a companion misdemeanor.
Senator Schroeder.
Thank you, Mr. Chair. And Senator Higdon, you and I spoke in the past, so I somewhat know the answer to this question, but for the committee's sake, have you talked to any Commonwealth attorneys about this, and have they expressed any concerns?
Yes, I have it, and they have some concerns, and I told them I'd be certainly glad to listen to those and file an amendment.
And I actually thought this came at the request of, maybe I misunderstood you when I spoke to you.
It did, but like I said, each is different. Some are a little more conservative than others. This was a starting point.
Okay.
But I did have a conversation with a Commonwealth attorney yesterday, and told him that I would certainly entertain a amendment if to this bill if there was something he was wanted to see addressed.
Senator Schickel.
Thank you, Mr. Chairman. Senator, you and I have talked a lot about this, and I admire your tenacity and your advocacy for this, because I know all your motivations are pure. And but I do just want to make a statement about maybe kind of the flip side of this, because I don't think it's been said. We've done a lot of this kind of legislation, and some of it I voted for, and some of it I voted against. But as a fellow that has worked a lot with prisoners and reentry, and back in a former life, I had this thing called the Boone County Jail Work Camp, where we matched up prisoners with employers. And contrary to what mainstream media and the state chamber tells you, and a lot of these advocacy groups, I never found a shortage of employers willing to hire people with a criminal record. In fact, they lined up at the door to do it. And I think if you talk to Senator McDaniel or you talk to Senator Carpenter, they'll tell you the same thing. The problem is not that. The problem is this. Once these folks get a job, many of them are incapable of keeping it. And there's a couple common denominators that we see: drug and drinking problems, alcoholism a lot. I'll never forget one time I had a restaurant hire a prisoner. I said, "Man, this guy's a great cook. He's going to be wonderful." And I was really excited about it. The next day, the owner called me, reaming me out, told me to get down to his restaurant. I went in the kitchen there. This guy was laying drunk. He couldn't even stand up. The lesson was he could perform in a controlled environment, but in an uncontrolled environment, he was incapable of it. So I find employers very, very willing to do this. And then a lot of them have some of it's anger management problems, appearance, punctuality, or just showing up's a big deal. All these different things. And almost always when they get fired or they lose their job, they want to blame it on the fact that they had a criminal record, when really that's not the case. You know, it's hard a lot of times for us to look into our mirror and accept really what happened. But what really happened was someone gave them a job, and for one reason or another, they couldn't keep it up. And that's why programs like our Senate president with alcoholism and drug abuse are so important, to try to find that secret sauce to help the people with. And I apologize for being so lengthy, but here's my point. I think we owe it to employers that take this risk. And I think we owe it to the public that takes this risk, that we don't hide anything from them, that they know what they're getting into. And I almost think if they know what they're getting into, the chances of success of employment might be even higher. And because a lot of these jobs are entry-level jobs, people going into people's homes and things like this, I think the public and employers kind of have a right to know what's going on and the background of a person. And I'm not sure it's prudent for the person wanting it or for the employer who's taking that risk to kind of hide that stuff at in such a short time. The other thing I would say is that if we have bad misdemeanors on the books, let's repeal those bad misdemeanors and get them off the books. Thank you, Mr. Chairman.
Senator Turner.
Thank you, Mr. Chairman, and I would like to speak a little bit in response to my good friend who just got through speaking. As a lawyer, I represent people every day that have these little things, and you've quoted a number of things, from the bringing a case of beer in from a dry county. Part of Harlem was dry, and I set mine up in the back of the car and said, "Police officer, you want to arrest me? I'm taking a six-pack home." Okay? But they didn't. But you have these people that have these little incidences, and you read so many, from milk to eggs to what have you, and then you have a kid that's in a car that's got no knowledge that the driver has a marijuana joint in the ashtray, and the law says you both get charged unless one of you takes that charge. So this innocent kid ends up has this on its record. Mm-hmm. Some employer's not going to hire him. One kid was going to drop out of the University of Kentucky College, didn't want his parents to know, and thank the Lord he called me, and we got it worked out. And I could go down the list of how many children that I've helped from off in college that's had that same problem. If you're in a car, 7 of you are in there, and one person has got a pill or a cigarette, marijuana, the police will write all 7 of you. And it's of record, and you can't get it expunged unless we do what you're trying to do here today. So there's another side to these stories. I have a little girl that was in Walmart with another girl that was shoplifting. She wasn't shoplifting, but guess what? Walmart charged her. And to get that thing expunged, you got to go through a process. She is now working at Walmart in the pharmacy counting pills. And they think she's the best employee. But guess what? If we didn't have that expungement process, and I threatened to sue Walmart, she wouldn't be able to work. She'd had to get out of college. She had a scholarship as a cheerleader. So there's so many. I could go down a list of hundreds of them. And I think we owe it to the public to do what you're doing here, Senator. And I want to say I support it 100% and appreciate what you're doing to help these young people. And it's young people who's suffering from it and are out trying to get jobs and trying to get education. They can't get housing. I've got one who's got charged. She can't get in the nursing program because you got to go through the aid program before you get the nursing program. But because she was riding in a car with some guy that went and bought some of what he said was marijuana, but it was different, and the police stopped. They charge her too, poor innocent, but she's still waiting on a trial date. She can't get in the nursing program. Once this thing gets over with, if we don't get it expunged, I could just keep going on, but I don't want to. I really appreciate what you're doing, and I've been doing this currently, and I respect my good friend's time, but I think if he was representing them today like I am, he would see a different picture. So I appreciate it. Thank you for what you're doing.
Senator Neal. Last question.
I have several, Mr. Chairman, if you don't mind. No, I don't. First of all, I want to thank you for Senator Higgin for bringing this bill. I think it's clearly a common sense measure. It's my understanding that this bill, 5 years would have to lapse before an individual can actually apply for expungement. Expungement is not necessarily automatic, and certainly in the realm of misdemeanors, we divide these things up into misdemeanors and felonies. Certainly in misdemeanors, 5 years is more than enough for a person to be clear of this and to have a second chance. Now, the reason I'm raising this in this framework is that contrary to what I have heard here, I'm privy to multiple situations where people have been denied a job because of some charge on their particular record. And I think that this is a reasonable way of approaching this, and I appreciate the fact you brought this. I guess I didn't have a question, Mr. Chairman, so I think it's a good bill. Thank you.
Thank you, Senator Neal.
All right, seeing no further questions and not allowing them if I did, do we have a motion and a second? All right, seeing no further questions, Mr. Secretary, please call the roll.
Senator Berg,
Aye.
Senator Carroll,
No.
Senator Kerr, Senator Neal, Senator Schickel,
No.
Senator Schroeder,
Mr. Chair, explain my vote.
Yes, sir.
I vote aye. I did, as Senator Hignan knows, have concerns on the underlying expungement bill that we passed a few sessions ago. I do think I have a concern for officers. I believe they should be able to know in a database, whether that's a law enforcement only database, and employers. You know, I am concerned for employers, but you know, I tried to fight that fight. I lost that fight, and to me, this bill really, in some ways, it is a cleanup. So I vote aye today.
President Stovers, Senator Turner, Senator West, Senator Wheeler, Chairman Westerfield.
Aye. That's 7-2. 2? Yes. 7-2, bill passes with favorable expression. Thank you, Senator. I appreciate it.
Thank you, Mr. Chairman and members of the committee.
Folks, I do anticipate having, that concludes our agenda for today. I do anticipate having a meeting most every week from here on out. So remember that for Thursday mornings at 10. I'm also going to institute a new rule starting next week, and I'll share that with you when we get here next week. Got nothing to do with donuts. That one's already in place. Yeah, that's been in place from 2013 at least, and maybe Tom Jensen had it in place before I got here. Thank you all.